Justice Ledwaba, you permitted me 1 hour and 45 minutes, but I won't take that full slot of time. Thank you. Justices, a lot of ground has already been covered yesterday by my various colleagues. In my address, I will try to avoid repetition of arguments that have already been made, and I will not repeat all of the written submissions that are made on behalf of the President and the government. Instead, I propose to highlight a few of the key legal aspects of the argument. And in that regard and to that end, I will turn to the following topics in turn. The first is why the DA is incorrect to say that the President and government should have said little, nothing if little, in this application. That the second is that the application is misguided. The pleadings don't make out a case. They don't make out a case in law or in fact. And such allegations as they are in the founding affidavit is not supported by facts. And the third is that in the absence of facts and in the absence of a properly pleaded cause of action, the DA is essentially seeking advice from this court regarding a political party policy. It doesn't resolve a dispute between the parties. And fourth and finally, that the relief that is sought is not competent. Those are the four broad topics I'll address. Beginning with the response by the President and the government. The DA complains that the President and the government ought to have filed a notice to abide and only an explanatory affidavit if necessary. And they say that what the President and the government have done is to provide a full-blown defense. And they complain about this. But this is why the President and the government were required to respond. First, the President was cited in this matter as a respondent. So was the government as a whole. Having been cited, they have every right to participate fully in the hearing of the matter. Second, the President is required to place full facts before this court in order to be able to assist it to come to a decision. This much is made clear in the Constitutional Court's decision in Matatiele, and it's in our heads of arguments, the reference. Third, the President had already testified about this, the impugned policy of the ANC before the commission, the State Capture Commission. So the DA's application included reference to the President's testimony in the State Capture Commission and also accused the President of not telling the truth. It was important that the President responds to that. Fourth, and quite importantly I would say, by taking a supine approach to the application, the President and the government would create the impression that the cadre deployment policy is actually binding on them, or that they think that the cadre deployment policy is binding on them. They do not. And they needed to say so, and why. Finally, it was necessary in the answering affidavit of the President and the government to set out the efforts that have been made to address the problem of improper interference in public appointments in order to end state capture, to rebuild damaged institutions, and foster the culture of accountability that is required by Section 195 of the Constitution. These measures validate the conclusion that the DA's application is premature. And it's exactly what the Matatiele court wanted, was for government respondents to be full and frank with the court. What kind of measures has the government been taking? Again, I won't go into the details. We've listed them in our written submissions. But some of the examples are that performance agreements have been signed by the President and every member of cabinet and have been published on the government website. There's a recommitment to the National Development Plan, and a key part of the National Development Plan is recognizing the need for a well-run and effectively coordinated state and state institutions with skilled public servants. In May 2022, the Minister of Public Enterprises, Mr. Godin, delivered a budget vote speech, and that is to be found on case lines section 002, page 729. And in it, he stated the steps that were being taken to address the problems of the state-owned enterprises within his portfolio, Eskom, Transnet, SAA, and the like. The speech runs on for a few pages, but it is very unambiguous in emphasizing the importance of remedying and rebuilding state institutions that have been damaged as a result of state capture. And the minister, in fact, dealt specifically with the Zondo Commission and says the following: Judge Zondo finds that the evidence presented to him revealed that the systematic corruption that collapsed governance in these institutions were led by certain board members and senior executives. These people need to be held accountable. So it's not just about what do we do to insulate our public service from such behavior going forward. It's also making sure that where that improper interference and the improper conduct by public officials is found, that they should be held accountable. Those that are already even no longer in the public service. The other measure was that once the Constitutional Court had determined that the previous NDPP had not been lawfully appointed, a public and transparent process, and this was unique. This was the first time first time ever that the appointment of the NDPP followed a very public and transparent process in order to identify the new NDPP. And the interviews were held in public, and it was in an effort to help South Africans regain confidence in that constitution, to evaluate for themselves those candidates who were there to follow the interviews, see how the final choice was made, and the final decision that was made, and the candidate was warmly embraced by all sectors as the new NDPP. The President and the government recognized that state capture was facilitated through the abuse of public sector appointment and dismissal processes. The remedy is to ensure that the policies of government and legislation related to public appointments are rigorously applied to insulate the public service from improper influence. This is precisely what the President has set out in his response to the State Capture Commission report. I do intend to refer to certain aspects of the President's response, and I'll do so shortly. The point is that it follows that there's nothing improper about the President's approach to this matter. It is in line with his obligations, not as the President of the ANC, but as the President of the Republic. And the DA did not deal with any of these measures that have been taken by the government and by the President. The DA simply contends that it doesn't matter what measures are being taken by the government and the President, they're just irrelevant. And that can't be correct, because it's in fact the state that is the primary duty bearer, not the ANC. What matters is the law governing appointments in public services and the implementation of that law. The President and the government referred to the history of the policy in order to make it clear that the government does not consider the policy to be permissive of a breach of the laws and regulations that govern public appointment. Holders of government office are governed by the Constitution and the law. Of course, manipulation of political appointments can occur. They will occur even in the absence of the cadre deployment policy. It's not an impossibility. But what the President has said is that they are concerned to put in place measures to prevent that. So whether there's a cadre deployment policy or not, the responsibility lies with the government. So what the presidential response, and this is linked also to the point that we had made about the premature nature of this application. When the State Capture Commission was established, the court order that gave effect to the former public protector's report required that the President responds in public to the recommendations of the State Capture Commission. This the DA knew, yet it brought the application without waiting for the President's response. The response of the President came on 22nd October 2022. It's a roughly 70-page response, and it deals with the recommendations of the Zondo Commission. This was submitted sometime after the DA's, it was submitted after our answering affidavit. And actually, Justice Ledwaba, at that point I should pause and then just say this at the outset. And for the case of just good hygiene, we submitted that affidavit after the answering affidavit, and it was accompanied by a condonation application for the late filing. And that was because the response was only made by the President on the 22nd of October. There's no opposition to the condonation application, but there is that application before this court. So the President's response then, if I can turn to that, it deals quite concretely, I would submit, with the issues of independence of key state institutions and the professionalization of the public service. The response can be found at section 2, page 1275 of the record. And it starts off in the preface by saying the following: corruption is a betrayal of our democracy and an assault on the institutions that we established together to advance the values of our Constitution and the interests of our people. It goes on in paragraph 19 of the response, and justices, to be clear, I'm not going through the whole thing, just to those that I consider to be most relevant for your purposes. So in paragraph 19, of our heads, we refer to section 2.1 of the President's response, where he says the following: government accepts the recommendation on the need for a process of the appointment of SOE boards that is not open to manipulation, including the involvement of independent panels with appropriate technical expertise to recommend suitable candidates to the relevant executive authority. Provision will be made in the final guide for the appointment of persons to boards and CEOs of state-owned and state-controlled institutions for these independent panels and the like. We then go on in paragraph 20 to cite some other responses, other paragraphs of the President's response. In a nutshell, what those paragraphs show, at paragraph 20 of a heads-up argument, is that there will be it explains the work of the Presidential Council on SOEs, that it is to consider a framework for appointing competent individuals with unquestionable integrity through a transparent and robust process, that the principles of the Commission's recommendations will guide government's reform on board appointment processes to ensure greater transparency and to ensure checks and balances. It says that provision will be made in the guide for the appointment of persons to these boards for different stakeholders and all relevant stakeholders to play a role in the appointment process and in nominating suitable candidates to the relevant minister. And the President says it's anticipated that the guide will be finalized in the 2023-2024 financial year. It also refers to the State-Owned Enterprises Bill and regulations which will codify the appointment process. So it's not just the policies that I've been referring to and the Presidential Council's role, it's also an amendment to the State-Owned Enterprises Bill, amendment to law, that will codify the appointment process. And the process will be legally binding. The President also speaks to professionalization. So far, I've been talking about the state-owned entities that we've all been very concerned about and the impact on our economy and on our society when those institutions fail. But the President's response also talks to the professionalization of the public service in general. And we set that out in paragraph 20.3 of our heads of argument. And it acknowledges, the President acknowledges that a key mechanism, in his words, of state capture was the strategic positioning of individuals in positions of power through the abuse of public sector appointment and dismissal processes. All public sector legislation governing professionalization will be reviewed and, where necessary, amended to align with the national framework of professionalization of the public sector. So, and it goes on and on. It's all in our heads. The relevant paragraphs are reproduced in our heads. And I commend the court to the President's response and those specific paragraphs. So what we are submitting is that the President's response demonstrates that the President is providing appropriate direction to ensure that public appointments are not vulnerable to abuse, regardless of what the ANC or any other party does with their policies. So the DA's contention that the President has no intention of revoking the policy is really neither here nor there. It's for the ANC to decide what it wishes to do with its internal policies. It's for the President to ensure that the Constitution and the law is upheld. On these measures, I'll repeat that we've not heard anything from the applicant to suggest that they are problematic in some way, that there are shortcomings in these measures that are being proposed and those that have already been taken. What the DA does say about the point of prematurity and ripeness is that the Mazibuko case is similar or analogous. And I submit that that is entirely incorrect. It's actually markedly different from this case that's currently under adjudication by this court. In the Mazibuko case, the respondents in that case, the speaker and the three respondents, the speaker and the chief whip, held differing positions. There was a dispute of fact that the court had to grapple with, and there had been an engagement with the respondents that failed. There was failed engagement. And there wasn't any reasonable possibility that the rules that needed to be amended would in fact be amended within a time that would be constitutional. The case was, however, also brought on an urgent basis. So there it was, very specific context. The cause of action had been fully pleaded. A direct link was made between then the section 102 of the Constitution at issue there and the rules of Parliament. And we were dealing there with the rules of Parliament. This is non-binding policy that the court is asked to have a look at. And the court in Mazibuko had also issued directives to the speaker and the chief whip to report on the progress of amending the rules so that it's in line with section 102, and that did not take place. So there was no prospect. The argument that, well, just because they say it's going to be done is not a ground for us not bringing an application doesn't apply in this case. So that is what I have to say about the President's and government's response and why it was necessary. And that there's no answer from the applicant as to why what is set out regarding the measures being taken and the duties on government is not sufficient. Duties as understood by the President and the government. The second issue is that I said I would turn to is that there isn't a valid constitutional attack. So what the DA's founding affidavit does is what it doesn't, let me put it that way, is it doesn't make specific allegations as to which rights in the Bill of Rights are violated, how they are violated, and by whom they are violated. Instead, the DA speculates that the speculates of rights violations in general terms. My learned friend referred to the founding affidavit yesterday, and where the DA says this, and I won't repeat the whole paragraph of the DA's founding affidavit, but basically the reference is to breaches of several fundamental human rights. That's not sufficient to make a case. Nor is it sufficient to simply say it erodes, the policy erodes the values of human dignity, equality, and freedom. So we have a situation of a case where we struggling to understand, frankly, what exactly the grounds of the Constitution, what exactly the Bill of Rights grounds are for bringing this complaint. There is a reference to Section 7.2 of the Constitution. This is wholly inaccurate. It doesn't apply in this case because it doesn't apply to a private party. And the DA doesn't explain why Section 7.2 should apply to a private party. The Glenister case does not help the DA because, as we know, that dealt with Section 7.2, which places the duty squarely upon the state. What 7.2 says is the state must respect, protect, promote, and fulfill the rights in the Bill of Rights. So that's not helpful. But the DA also doesn't tell us why Section 7.1 shouldn't be applied or Section 7.3. So there's a reference to Section 7. The reference is to Section 7.2, which applies to the state, but not to explain how Section 7.1 or 7.3 apply. And Section 7.3 talks about the limitation and when it is reasonable and justifiable to limit the rights in the Bill of Rights. There's no explanation as to how this framework of Section 7 applies in this case. My learned friends yesterday also dealt with the context of the Glenister case and why it was different and what was important about the issue of independence there. I'm not going to repeat those submissions, just simply to say that that context was important because it was dealing with a law that was removing measures that had been provided previously that safeguarded the independence of what was then called the Scorpions. So it is a very distinguishable set of facts. Then we come to Section 8 as another potential ground. But the DA makes reference in only one short paragraph to Section 8 of the Constitution in support of its case. One assumes that it's in support of its case that the Bill of Rights is applicable to private parties. In paragraph 105 of the founding affidavit, Mr. Steenhuisen says, Section 8 of the Constitution binds both the state as well as natural and juristic persons to the provisions of the Constitution. Political parties are not permitted to adopt policies that is at odds with the Constitution. And on that paragraph, the DA wished to construct a case. But what is misguided about this, and what the DA misunderstands, is that the point regarding the application of constitutional rights to private parties is quite a nuanced one. It's clear that the Bill of Rights applies to private parties. But what does it say in the text of Section 8? Because it's not a simple exercise, and it's not a simple statement in the Constitution of the binding nature of the Bill of Rights to private parties. So I think it's necessary for the court to have a look at Section 8 in its entirety. The courts have already had cause to interpret this, and I'll come to that. So Section 8.1 says the Bill of Rights applies to all law and binds the legislature, the executive, the judiciary, and all organs of state. So this is not qualified in any way. Bill of Rights applies to all law, legislature, executive, judiciary. In 8.2, this is what the Constitution provides. A provision of the Bill of Rights binds a natural or a juristic person if and to the extent that it is applicable, taking into account the nature of the right and the nature of any duty imposed by the right. The section then goes on to deal with when applying the provision and common law and how that works. That's not necessary for us to get into the purpose of this case. The real crux of the application of Section 8.2 in this case, so Section 8 lies in 8 subsection 2, which is, as this court will see from its wording, heavily qualified. And my learned friend, I think for the amicus, referred to Holoniso versus Command. There were two judgments. There was the one in the High Court and the one at the Constitutional Court. In Judge van der Westhuizen's judgment, he says, I quote the following about Section 8 and the application of the Bill of Rights to private parties. He says, a court is not called on to determine merely whether a provision is at all capable of application, but whether it should be applied to a certain situation. The fact that the dimension is to be added to the previously mentioned one, the fact is that this dimension must be added to the previously mentioned one is, to my mind, clear from the phrase following the word applicable. So the phrase is to apply to the extent that it is applicable. He goes on to say, it is clear from Section 8.1 and 8.2 of the Constitution that the Constitution distinguishes between two categories of persons and institutions bound by the Bill of Rights. Section 8.1, I've already said, binds legislature, executive, judiciary, no qualification. Justice van der Westhuizen says the following, Section 8.2, however, provides that natural and juristic persons shall be bound by provisions of the Bill of Rights to the extent that it is applicable, taking into account, as the provision says, the nature of the right, the nature of the duties, the particular situation, the particular context. So that's the first thing I wish to say about the structure of Section 8. It also talks about the Bill of Rights. It doesn't talk about the Constitution. It says that natural and juristic parties will be bound by the Bill of Rights to the extent applicable. And the reference then, when the court is required to determine whether any particular right is applicable and to construe the applicability of Section 8.2 to a case, doesn't mean that when there's a contention that it is not applicable, that what that means is that there's a constitution-free space. That is not the point. That phrase comes from Justice van der Westhuizen's judgment in De Lange, In fact, my learned friends referred to paragraph 73 to 76 of the De Lange judgment. But what they did not refer to is paragraph 83 of that judgment, where the judge recognizes that rights compete and that different obligations apply on different actors. At paragraph 83, Justice van der Westhuizen says the following, paragraph 83 of the judgment. He says, the Constitution is more than law, however. It's the legal and moral framework within which we have agreed to live. It also not only leaves, but guarantees space to exercise our diverse cultures and religions. I would pause to add that one might include political views, and to express freely our likes, dislikes, and choices as equals with human dignity. In this sense, one could perhaps talk about, and he uses this phrase, constitutionally permitted free space. This is quite different from contending that certain areas in a constitutional democracy are beyond the reach of the Constitution or Constitution free. So it would not be correct in this court were to find that the rights are not applicable in this case. It would not necessarily follow that that finding means that the Constitution, that there's certain spaces that the Constitution doesn't reach into. The point is that when you do analyze and when you do wish to bring a case to say that in this context where there's a private party with these with this conduct or these rules, the Constitution should, the Bill of Rights should apply, and to justify that with reference to facts and law. And it may be that the proper analysis requires that other rights are given weight, and the balancing exercise means that the particular impugned law or conduct is in fact constitutional, but it doesn't mean that it's a constitution-free space. My learned friend Mr. Morrison yesterday referred to freedom of expression, and that ought to be weighed in the balance. So would the Section 19 right of the Bill of Rights, the right to political participation. So it's quite clear that the space and the jurisprudential reasoning regarding Section 8.2 of the Constitution is a complex one. And in such contested terrain of the circumstances when the Bill of Rights is binding on a private party, the DA chooses to bring an abstract case, not a concrete case. What a space might look like, what a case looks like, and when it applies, requires much more, when Section 8 applies, requires much more than a bold assertion that law or conduct undermines constitutional rights. Just on that score, the founding affidavit referred to, just find my reference, I'll find it in a moment. It refers to the allegations in the state, the evidence in the State Capture Commission, and that the application relies on the evidence that was led before the State Capture Commission. We've heard in oral argument yesterday that, and of course there was opposition to the use of that evidence as proven facts. We hear in oral evidence yesterday that that is correct, that they are not to be taken. This court is not required to determine whether those facts are true or not, or whether the evidence or whatever was said at the Commission is true or not. It is simply there for illustrative purposes, emphasizing my point of the abstract nature of the case. So, So much then for the facts that have been provided, the insufficient basis to be able to enable this court.
Do you understand what you say that the DA did not specify the rights which they
They need to be specified, but it also needs to be justified. So we're dealing with a policy, as we said. It's not a government policy, it's not binding. I wouldn't go into, our heads of argument deal with this. We refer to the Carney Garden Route case about how one evaluates government policy. Sorry, I wish just to correct what I said a moment ago. It's that policy is not always binding. That case spoke about government policy and said that it's inherently vague and may bear different meanings. And the court went on to say that in order to bind the public, the policy should be reflected in instruments, in legislative instruments. So that was the Carney Garden Route. But there's another case that I did not refer to in my heads of argument. It is in the bundle. It's the Esau case. It's Esau and others versus the Minister of Cooperative Governance and Traditional Affairs and others. And in the law reports, it's 2021, volume 3, SA 593, and it's a judgment of the Supreme Court of Appeal. And what the court said, and it was a unanimous judgment, what the court said at paragraph 45 is that as a general rule, policies that have been formulated and adopted by the executive will not be ripe for review until they are implemented. Usually after having been given legal effect by some or other legislative instrument. Two principles come into play in this regard. First, that in order for an exercise of public power to be ripe for review, it should ordinarily be final in effect. And secondly, that the decision must have some adverse effect for the person who wishes to review it, because otherwise its setting aside would be an academic exercise which courts generally eschew. The court went on to say that it's not, that they accept, or in that case, Judge Plaskett says, I accept, however, that the mere fact that the impugned conduct involves the formulation or adoption of a policy does not necessarily mean that it's not justiciable. And that was in reference to the treatment action campaign case. This policy is not a government policy. It is not a law. It has no legal effect. The president and the government are not bound by it. And the DA has not made specific allegations that the president or the government threaten to violate any right or law as a result of this policy. So Section 9 of the Constitution, 9 of the Bill of Rights, right to equality. Here, the DA states that the chairperson of the State Capture Commission recognized that the cadre deployment policy, the cadre deployment committee rather, undermines or may undermine the principle of fairness and equality. And they say, and as the facts illustrate, the policy has proven to promote candidates who are not fit and proper and do not have requisite training skills or competence. But again, the DA has not made out a case for the violation of the right to equality at the level of fact or law. It doesn't refer to Section 9. It doesn't explain which parts of the policy defend the right to equality, nor how that conclusion is reached. More importantly, factually, the DA does not connect any particular appointment to the policy, nor to any inequality. It conflates government policy and government conduct with the policy. Any person may wish for the appointment of people who are aligned with their values. That doesn't mean that if such a person is appointed, the appointment is axiomatically inappropriate. The decision lies with the responsible official. So there aren't facts on Section 9. There's a broad reference to fairness and equality and values of the Constitution. My learned friend spoke yesterday about the principle of subsidiarity, and I submit with respect that he has it wrong. What is required for a challenge on the basis of equality or unfair discrimination must be made in terms of the statute enacted to give effect to the right to equality. And we know that that statute is the Equality Act. We've referred in our heads of argument at paragraph 32 to the applicable case law. It's now a trite principle, yet the DA makes no mention of the Equality Act, let alone meet the requirements of the Equality Act. It makes no argument as to, well, it makes no reference to the Act, but it also doesn't, the DA doesn't make an argument as to why the subsidiarity principle should not apply in this case. So this constitution, this challenge, which seeks to invoke equality without more, must fail. The amicus said that there's no need to apply the Equality Act. That's just not correct. Section 9.4 of the Constitution, Section 9 deals with equality, and 9.4 specifically says national legislation must be enacted to prevent or prohibit unfair discrimination. That legislation is the Equality Act. So we then come to I think what is the final potential leg of the DA's case, and that the policy is inconsistent with the rule of law. Because the cadre deployment committee acts without any lawful basis for doing so. But this is extraordinary. The cadre deployment committee is not an organ of state and does not exercise any state power. Decisions for appointment are governed by the laws applicable to the position sought to be filled, and there are different processes depending on the particular position. That decision is taken by officials in accordance with the relevant prescripts. And it's a chain of events. The appointment process is a chain of events that take place over a period of time, comprising advertising the position, receiving applications, shortlisting applicants, interviewing persons with the position, selecting and appointing eventually the people to the positions. All those responsibilities lie in the government. The law doesn't contemplate that the cadre deployment committee play any role in any of those steps. And we've referred to the Constitutional Court decision in the Public Protective of the President of the dividing line between a private entity and the organ of state. And I'll just merely refer to this in paragraph 80 of our heads. I won't quote from that judgment. Yes, so sorry, I've just lost my place for a moment. With the rule of law, the DA doesn't set out, apart from the legal principles and the lack of legal reasoning and proper application of constitutional principles, there are no facts to support it. Such facts as there are examples, and those examples we deal with in our heads of argument, and it's set out in the DA's founding affidavit at paragraph 73, the specific named people that they refer to. But what's important about those, and this is about pleading, proper pleadings, is that nowhere are those appointments linked with the application of the policy. In fact, the DA doesn't even attempt to do so in most of the examples that they've cited. The one example that came up in debate with Justice Baum yesterday was the appointment of Mr. Moyane to head the South African Revenue Service. But what the founding affidavit says at paragraph 90 is the following. Mr. Moyane also testified that he was aware that Mr. Zuma had earmarked him as the Commissioner of SARS before his appointment. So you're talking there about something entirely different. You're talking about an abuse of the appointment processes. And Mr. Moyane speaks to that himself, that it was not the ANC, it was not the application of the deployment policy or decision of the committee, it was the president at the time. The DA doesn't respond to these things. It doesn't respond. It doesn't say why, nevertheless, this court should take those examples into account. It just denies the version of the respondents, and it reiterates that the examples are illustrative of how cadre deployment promotes corruption and state capture. But it really doesn't assist them. It's actually quite pointless, because at best it shows that the problem is the abuse or circumvention of the policy, rather than an inherent unconstitutionality of the policy. And again, that is assuming that the policy is even appropriately challenged in this case. I'll make one final point about the pleadings and the grounds. There's a reference to constitutional principle 30. There's not much. There's as with the others, there's sort of scant allegations and averments and argument with regard to that constitutional principle. All I wish to say to this court is that it's interesting, the constitutional principle. It was part of the constitution-making process. It informed the text of the final constitution. And it was the final constitution itself was tested rigorously by the Constitutional Court in the certification proceedings to ensure that it was not inconsistent with the constitutional principles. So it's not appropriate to rely on a constitutional principle to make a case. You have to rely on a provision of the Constitution, and in this case, a provision of the Bill of Rights. So it just simply is not a ground for a constitutional challenge. And then a short word on the abuse of the policy. To the extent that the argument is, to the extent that one accepts that where appointments were improper, it was an abuse of the policy rather than an application of the policy. That doesn't assist the DA either, because that fact that a policy may be abused, this is a policy of government which we're not dealing with here, is not a cause for a declaration of invalidity. So, quite apart from the fact that this policy is not law, the Constitutional Court has held that where a law is abused, it doesn't follow that the law is unconstitutional. It is the case of abuse that must be addressed. And we refer in our heads to the judgment in Bernstein versus Bester in paragraph 71 of our heads. And that case dealt with the power of subpoena within the Companies Act, and said that the fact that the power of subpoena may possibly be abused in a particular case to the prejudice of the person subjected to such abuse does not mean that the power should, for this reason, be characterized as infringing Section 11.1 of the Constitution. The court was dealing with interim constitution, and 11.1 was the right to freedom and security of the person. So that the court made clear in Bernstein versus Bester. They also repeated this in the Van Rooyen decision, which is quite appropriate to the point of when a declaration of invalidity may be used. And it's the Van Rooyen decision of the Constitutional Court. It's at paragraph 72 of our heads. And the relevant extract of the judgment is the following. The court says any power vested in a functionary by the law, or indeed by the Constitution itself, is capable of being abused. That possibility has no bearing on the constitutionality of the law concerned. The exercise of the power is subject to constitutional control and should And should the power be abused, the remedy lies there and not in invalidating the empowering statute. So, again, with my caution that when I refer to the policy, the cadre deployment policy, it's obviously not government policy, but the reasoning can be applied. It can't be construed as binding, but even if it were, the policy doesn't require ministers to implement deployment decisions of the cadre deployment of the cadre deployment committee. To the contrary, in fact, it states that the powers of the ministers be respected. So these averments, all of these supposed grounds in the Constitution for a constitutional violation simply do not meet the degree of specificity that is required in constitutional litigation. And we've referred to the case law that's authority for that proposition. And that is the case of Fisher. It's in paragraph 41 of our heads. And it's also in the De Beer case, where the court stated that a generalist statement of the human rights infringement doesn't suffice in court. And that case is cited at paragraph 43 of our heads. And importantly, what the SDA held there, and that also was a unanimous judgment, the SDA said the following: at the very least, it was for the respondents to allege, the respondents in the appeal court, to allege A, each specific regulation sought to be impugned, B, which constitutional right was alleged to be violated by the impugned regulation, and C, how the regulation allegedly infringed the specific right. Absent this, it could hardly have been expected of the minister to appreciate the scope of the challenge and put up necessary evidence to justify the regulation. It was not for the minister to do so. So I must admit that this case is very similar, because it requires a court. And in fact, to the point of the remedy, when the question was posed on section 172, my learned friend for the DA said that the court may invalidate a policy to the extent of its inconsistency, because that's what section 172 requires. But how is the court supposed to determine the extent of the inconsistency when it's not put before the court? So, the point about that, if the court were to look at the contents of the cadre deployment policy, you'll see that there are numerous references in that policy to the empowerment of women, to youth empowerment, to professionalizing the public service, to transparency in accordance with section 195. Why should that be found to be unconstitutional? The DA didn't respond to that. So that is the end of the section on our submissions, that there is no valid constitutional case that has been made to this court. The third topic I said I would speak to is the relief, because the two go hand in hand. The relief is dependent on the specificity of the case. So the fact that the court has a discretion to make an order of constitutional invalidity, of invalid law or conduct, doesn't mean, what it means is that it must be persuaded, for it to make that, to exercise the situation, it must be persuaded that there is a valid constitutional claim, that the impugned law or conduct, that's what section 172 refers to, is unconstitutional, and the specific ambit of the unconstitutionality. So the remedy must fit the finding of unconstitutionality, having regard to the extent of the unconstitutionality, and whether the remedy will serve to deter further violation. In response to the objection raised concerning the vagueness of the remedy, the DA states that the policy as a whole is unconstitutional. I've already said that there are aspects of the policy that can hardly be said to be unconstitutional. In fact, they further some of the provisions of the Constitution. So that approach taken by the DA that the policy as a whole, and that it's competent for the court to simply declare it as a whole unconstitutional, is a diversion from what the Constitution commands in Section 172. The only circumstance in which, the only circumstance where a whole policy, a whole of the law or conduct can be set aside, is when the manner in which the instrument was brought into being was unconstitutional. So that's the only case when the entire instrument has been declared unconstitutional. We refer to the authorities for that proposition at footnote 62 of our heads. This case, nowhere in this case does the DA contend that the manner in which the policy was put in place was inconsistent with the Constitution. The second important thing to say about declarations of invalidity is that it must be, says the Constitutional Court and the Minister of Health versus TAC, references again are in our heads, but the principle is that a declaration of invalidity must be in a form which identifies the constitutional infringement. If the relief sought does not do so, it renders the matter academic. And we refer to a 2022 judgment of the SCA, which, Justices, we did look to see if it's been reported, but not yet reported. But it's cited in footnote 64. It's a judgment of the SCA where the court said the following: courts are loath to grant orders that have no practical effect or result. It is self-evident that futile orders lead to a waste of overstretched judicial resources. The court then refers to previous case law on this and confirms that what is required is the settlement of concrete controversies, or concrete controversies and disputes between parties. So that is not achieved in a remedy that simply says this policy is unconstitutional. The third principle of constitutional remedies is that a court should not ordinarily decide a constitutional issue unless it is necessary to do so. And the relief sought by the DA doesn't allow the court to determine what parts of the policy are inconsistent. And it doesn't make out a case. And this court should exercise its discretion not to grapple with what's clothed and described as a constitutional issue when it isn't. It's open, of course, to any interested party to challenge the constitutionality of law and conduct. But again, it must be factually grounded. And we've said in our heads of argument that we've explained why it's important to, in constitutional pleadings, make that causal connection, not just to get out of the starting blocks, but for the court to be able to provide a remedy that is appropriate and effective. The correct approach we would submit to challenging improper appointments is to challenge those specific appointments where the appointee doesn't meet the minimum qualification requirements, or there's evidence that the appointee is compromised such that the appointment is improper. And the DA, as we know, has done so successfully in the past. But an abstract case dealing with broad-ranging relief, the effectiveness of which is questionable, is not the way to deal with ensuring a capable public administration. We submit that the DA's application accordingly should be dismissed, with costs, including the costs of 2 counsel. Those are my submissions, and if I can assist the court any further.
What would you say about the cost in respect of the amicus? So the cost against that. Do you have anything to say on the cost?
My Lord, we will not seek costs against the amicus. It doesn't mean that we agree with anything the amicus has said or don't find it objectionable, in fact, some of those submissions. But we do not seek costs against amicus. Oh, I've been reminded of one other point. Sorry, Justices. Our heads deal with Section 195 and Section 197 and the constitutionality of the Public Service Administration Act. I haven't repeated it here. My learned friend is going to deal with it. But what I will say is the arguments that I've made already about the application of Section 8.2 applies also to 195, 197. Thank you.
Time to adjourn and we'll resume for the next.
Said little, nothing if little.
Thank you, Justice Ledwaba. We are grateful to those who have spoken before us, especially Mr. Salukazana and Ms. Hassim, in defending the constitutional validity of Chapter 4 of the Public Service Act. I'm not going to repeat what they have said in that regard, except to complete some of the submissions they have made. Our approach is not to repeat what we've said in the haze of argument, but simply to reflect upon the DA's oral submissions with a view to assist the court. We assume that the DA will accept in its replying submissions that the minister we represent is entitled to be here, and that he did not sneak via the back door to seek audience before this court in order to oppose the alternative relief sought by the DA in paragraph 4 of its notice of motion. Not only is the minister entitled to be here to oppose the DA's relief in that regard, but the minister has a duty to appear before the court in order to assist the court to assess the soundness or lack thereof of the DA's attack. In case lines, we have referenced the judgment of the Constitutional Court in Van der Merwe, and I've asked Mr. Salukazana to present the specific reference of the judgment on the case line platform. The court will see that there is now a presentation by Mr. Salukazana of the judgment concerned. But the key passages that we ask the court to consider are paragraphs 7 to 9, which make it quite clear that the minister of the kind we represent has a duty to appear before the court, to assist the court to assess the contentions of the constitutional attack by the DA on Chapter 4 of the Public Service Act. What we wish to do in representing the minister is to draw the court's attention to deficiencies in the DA's application, which have not been dealt with by our learned friends for the first 5 respondents. We would reflect in that regard the fundamental misconception by the DA in its failure to appreciate a clear distinction drawn by the Constitution itself, specifically Section 1971, between the public administration in general, referred to in Section 195 of the Constitution, on the one hand, and the public service as a specific subset of the public administration. It is not us, but it's Section 197 which draws the distinction. It is failure by the DA to appreciate that distinction, which leads to a generalized constitutional claim, and on the basis of the evidence, which does not relate at all to allegations of corruption in the public service. The entirety of the evidence relied upon by the DA relates to allegations of corruption and findings made by Justice Zondo in the public administration other than the public service. In that context, we will try and be as helpful as we can to the question Justice Ben posed to Mr. Salukazana about that issue relating to Mr. Moyane, because the DA made certain general claims about Mr. Moyane as an indication of the consequences of cadre deployment, which gave rise to either corruption or weaknesses in SARS. What we hope to do in that regard, Justice Ben, is to show the court that SARS is not part of the public service as contemplated in Section 197. And the provisions of Section 2 of the South African Revenue Service Act make it quite clear that SARS is not part of the public service. So that the evidence the DA presents in that regard does not assist it in the attack against Chapter 4 of the Public Service Act. It is that lack of alignment between the DA's evidence of allegations of corruption through the evidence it relies on that indicate why the DA's failure to appreciate the distinction between public administration and public service is unfounded. The second point we would like to address is the repeated central concerns all members of the bench put to the DA about precisely what is the nature of its case. Does it rely on that extract in the Zondo report in order to suggest that there is a finding by the Zondo Commission that the policy is unlawful and inconsistent with the Constitution? Or does it rely on that policy for some other reason to try and make the link it seeks to do between the deployment policy on the one hand and corruption it relies on the other hand? It is difficult, again, to appreciate the nature of the DA's case, because when our learned friend yesterday for the DA opened his submission, he indicated to the court that this case is not about corruption 101. Don't understand why Leonard Friend would say so. In the light of the pleaded case by his client, if the court were to go to case line 002-15, paragraphs 23 and 24, the court will see that the DA pleads a case of a link between the deployment policy and corruption. It says, for instance, in paragraph 23, on 28 April 2021, the President appeared before the State Capture Commission. Although the President did not address all of the DA's questions regarding the policy of cadre deployment, it was clear from the President's testimony that the policy was responsible for widespread corruption, state capture, and erosion of state institutions. There it draws the link. Paragraph 24, yet in his testimony, the President sought to defend the policy of state capture of cadre deployment, remarking that the cadre deployment cannot be faulted in principle. And then they refer to the President's evidence. We asked the court to add another reference which repeats this type of a case by the DA. It is case line 002-40, paragraph 93. What the case of the DA reveals is that it seeks to make a connection between cadre deployment policy through the deployment committee and allegations of corruption investigated and findings by the Zondo Commission in that regard, to invite the court to either interpret or invalidate Chapter 4 of the Public Service Act. We invite our learned friends for the DA, in the light of the opening submissions he made yesterday, to tell the court where does he stand in regard to the connection the DA sought to make in the founding affidavit. Does he still maintain that this case is not about corruption 101? It's only about the lawfulness of the policy. We leave him to make a choice for his client in that regard. But whatever the connection he may make, we submit that the evidence that the DA relies on does not show at all that the public service as presently constituted and operative is the one which is not contemplated in section 195 to 197 of the Constitution. because the DA has not presented before the court any evidence of an audit around how in the public service, I'm not talking about public entities, how in the public service the audit reveals that there has been a type of a public service not contemplated in Section 195 of the Constitution and Section 11 of the Public Service Act, so as to engage the constitutional concerns of the kind it makes. Nothing of that sort. What the DA does in its case is to refer to evidence which was presented before the Commission relating to public entities. We would like to draw the court's attention to Section 195, which makes a clear distinction between organs of state and public entities. They are part and parcel of the public administration, but they're not part and parcel of the public service, because their appointments, as revealed from the very evidence the DA relies on, the appointments of Mr. Malefe and all other chief executive officers of the past relating to those public entities were done not in terms of the Public Service Act, but by the boards that Justice Zondo reflected upon. Those boards were not accountable to the minister. Those boards were accountable to the ministers of the line functioning portfolios. The next issue that we would like to deal with, again reflecting on the central concerns of the court, is why is the DA here when it seeks to invite the court to exercise its discretionary remedy of a declaration of invalidity, when there are other appropriate remedies that are suited to the kind of the complaints it makes in that regard. I do recall quite specifically that it is you, Justice Ledwaba, who asked our learned colleagues for the DA whether there are other suitable remedies of the kind that would redress effectively the complaints it raises around appointment of individuals wherever under the questionable concerns it has on cadre deployment. With the greatest of respect, our learned friends for the DA have not risen up to the challenge to deal with that concern. We will indicate to the court, with reference to the extract of the Zondo Commission the DA relies on, that therein lies the answer, which it failed to give to the court, but Justice Zondo gave to the court in the text of that extract around what will be constitutionally impermissible. But secondly, the DA has not even reflected upon Section 196 of the Constitution, which is remarkable because it took the court to Constitutional Principle 29, which was dealt with in the first certification judgment, relating to the weakness of the initial text relating to the independence and the security of tenure of the Public Service Commission and the commissioners. You would recall and would give the court references completing the submissions made by learned friend Ms. Hassan on how the Constitutional Court refused to certify the initial provisions of Section 196 of the Constitution. In the second round of the certification debate, the court was satisfied that the text of the amended Constitution complied with Constitutional Principle 29 and 30, and therefore certified Section 196 as constitutionally compliant with those constitutional principles. One of the provisions will address the court on, relating to the question you posed, Justice Ledwaba, is Section 1964, which provides effective remedy should there be concerns in the public service around the use of the cadre deployment policy inconsistent with the requirements of Section 195 of the Constitution. Secondly, Thirdly, we will address the court on a number of judgments the DA relies on regarding the questions of intervention by this court, to show that each and every judgment the DA relies upon show that it ought not to have approached the court it did at the moment, and therefore you will be entitled not to intervene based on a pure attack of the policy. And lastly, we will address the question of remedy. And whilst we regret the earlier advice we gave to our client not to pursue a cost order against the DA, we would simply not make any submissions on the question of costs regarding the minister's involvement in this case. We leave it up to the court to decide whether this is one of those cases where the DA should not receive the benefit and protection of the BioWatch judgment. May I then begin by asking the court to go to the DA's heads and consider the basis of its application. It is case line 006-11, paragraph 12. And unlike our learned friends for the DA, we will try to be faithful to the text of the finding by Judge Zondo, so that we should not be criticized of misrepresenting the full import of the text and its consequences. And I ask the court to read together with me what the DA says about that extract in paragraph 22. And I quote, "What is said above makes it clear that within the current constitutional and statutory framework, it is unlawful," and I emphasize, it is unlawful for a president of this country and any minister, deputy minister or director general or other government official, including those in parastatals, to take into account recommendations of the ANC Deployment Committee or any deployment committee or any similar committee of any political party in deciding, and that's the operative phrase, in deciding who should be appointed to a position in the public service or organ of state or parastatal, so that the yardstick of the unlawfulness arising from allegations investigated by Justice Zondo is a decision to appoint. It is not the policy itself which would give rise to unlawfulness. It is a decision to appoint. But it's a decision to appoint not in the air. It's a decision to appoint by the relevant executive authority. So that if one looks at this finding by the commission and seek to use or test it for unlawfulness, one will have to look at the decisions made by the relevant executive authority, relying on a policy, whether of the ANC deployment or any other political party, so that we would submit on the face of it. Justice Mujapin, when you posed a question to our learned friend, whether Justice Zondo made a finding around the unlawfulness of the policy or its unconstitutionality, the answer is clear from the text of the finding by Justice Zondo, extrapolated by the DA in paragraph 22 of his founding affidavit, that there has not been a finding of that sort by Justice Zondo. It would have been odd, we would submit, for the learned judge to make a finding of that kind in the light of the judgments of the Constitutional Court we will explore before, one of which has been referred to by my learned friend Mr. Salukazana yesterday, so that we would submit on the central issue you raised with our learned friend, which, again, with the greatest of respect, they have not risen up to the challenge to squarely deal with that concern. The answer lies in Justice Zondo's own words that he did not make a finding in that regard. We would like to draw some conclusions which flow from this text of the finding. The first is the one that I have already presaged before, is that the trigger of unlawfulness is not the policy, but the taking into account of what the policy has said in that regard. Secondly, we don't understand Justice Zondo's finding to suggest that any influence, and that's the DA's suggestion, any influence in the appointment of relevant officials, either in the public service, parastate laws, or other organs of state, is unlawful by the mere fact of influence. It will be a far-reaching contention for the DA to make, particularly in the light of his reference to the Glenister II judgment. We would recall that in their heads, the DA has referred to the Glenister II judgment, the 2011 Volume 3 judgment of the Constitutional Court, where there were attacks relating to the amendment of the National Prosecuting Act and the SABC Act in order to replace the scorpions with the hawks. The Constitutional Court was quite concerned about the allegations of corruption made in that regard. But one of the points it investigated was what type of influence would raise constitutional concerns around the independence of the DSO, the hawks. And Justice, or Chief Justice at the time, Ngobo, made it quite clear that it's a question of undue influence, which will give rise to constitutional concerns. And we understand why he qualified the degree and nature of a disconcerting influence of the kind that would raise constitutional concerns. Because appointment generally in the public service, and the minister has given the court chapter and verse on how they work, under which instruments, it's a matter of interlocking cooperative discussion around various officials that are involved in the question of appointment. The minister has explained that there is always an advertisement, there is always a shortlisting, there is always an interview panel that interviews competing parties. It's a process which does not happen, as the DA suggests, in secret, Nicodemously, under the invisible guiding hand of the deployment committee elsewhere. It's a transparent process the minister has talked about. The DA has not challenged what the minister has said in that regard. So we would submit that it is quite clear that the Constitution does not outlaw any form of influence. The Constitution outlaws undue or impermissible influence. And the case of the DA, as we understand it, centers around a mere fact of influence. The second conclusion we would like to draw in this regard is we are not aware of any case, whether of this court or the Supreme Court of Appeal or even the Constitutional Court, which says that a court, when it deals with constitutional claims or challenges, must operate on the assumption that a relevant executive authority would act unlawfully. The DA's case assumes forever in the day and along all the processes of appointment that the relevant executive officials will act unlawfully because of the cadre deployment policy, for as long as the ANC is the ruling party. We would submit that that approach is mistaken and indicates why the DA's concerns are premature and ought not to engage the powers of this court. Far from it. The assumption is the other way. We rely on the judgment of the Constitutional Court in this time Glenister 1, paragraph 55, Mr. Salugazano would lift up that paragraph and I'd like to draw the court's attention to it in case lines. Are you reading from the paragraph 5?
It's
5? I believe that the judgment, the relevant passage, paragraph 55, is in case line 007-581. The UDM also argues that having regard to what it refers to as the relative marginalization of the legislature and the dangers of one-party domination, the court should act because no one will. I cannot agree. The role of this court is established in the Constitution. It may not assume powers that are not conferred upon it. Moreover, considerations raised by the UDM do not establish that irreversible and material harm will eventuate should the court not intervene. So that we would submit, when the DA seeks intervention of this court without any concrete case, it must show that there will be irreversible harm which would eventuate if this court does not intervene at the moment. We submit that the DA has not established irreversible harm, especially in the light of the remedies available to it, which we will explore in due course. There is a passage in this judgment where the Constitutional Court refused to intervene because it concluded that it cannot assume that the bills which were sought to be prematurely challenged, when they will be presented before Parliament would simply act in line with the dictates of the ruling party flowing from the Polokwane Conference resolution that the scorpion must be disestablished. I'll ask my junior to get the specific line for the court in that regard. But the Constitutional Court says it should make the assumption that as and when Parliament considers those bills, even if the ruling party wishes the bill ultimately to reflect the resolutions of Polokwane Conference, Parliament will do its job to make sure that the bill concerned in a final legislative format reflects the independence of the DSO. We would rely on that passage simply to make the point that this court will be entitled to assume that as and when relevant appointments are made in due course, the ministers concerned, the boards concerned, the Director General concerned will act lawfully. And if they don't, then the court will be entitled to intervene at that point in time. This takes me to a number of judgments the DA has relied upon in order to urge the court to intervene at this stage. The first, of course, is the Mlokoti judgment. It was dealt with yesterday by my learned friend, Mr. Morrison, I'm not going to repeat what he said in the regard. The simple point we would like to make with reference to the judgment is there was already a decision made by the relevant municipal council at that point in time to appoint someone. It is a challenge to that appointment which became a subject matter of constitutional investigation. And we would submit that that case indicates how and when constitutional concerns arising from an unlawful implementation of the deployment policy would be ripened for decision. The second judgment the DA relies upon is the Glenister number 2 judgment. I've already touched upon that judgment, but what was quite clear is that the judgment flows from the history of an earlier judgment, which is Glenister 1, where the court refused to intervene in Glenister 1, but intervened in Glenister 2, because by the time it intervened, the bill had become law, which became a subject matter of constitutional investigation. The third judgment is the DeLange judgment, which my learned friend Ms. Hassim dealt with this morning. The judgment is important because the DA relies on it in order to suggest that this court must reach private activities of political parties because they engage the provisions of Section 195 of the Constitution or some other provisions of the Bill of Rights. Ms. Hassim has dealt with the weakness of the DA regarding the claim that the deployment committee violates parts of the Bill of Rights. I'm not going to deal with that. What the judgment indicates is that the issue came before the Constitutional Court after a decision had been made by the relevant organ of the church, which had an implication of Minister DeLange on the right he or she asserted based on her orientation. You would recall that the church suspended her and sought to terminate her membership of the official position she held because she wanted to marry someone based on her sexual orientation, something which the church thought that it was inconsistent with its religious discipline. But the point is, at this stage, there was a decision already made in that case, and that decision was the one which became a subject matter of a constitutional inquiry. I'm not going to address in full the question whether the DA is right in relying on that judgment to suggest that there is no constitution-free zone of the kind which the court should respect and not interfere in all cases where there are private law implications to the Bill of Rights. Ms. Hassim has addressed that issue. What we would like simply to conclude based on her submissions is the fact that DeLange is not an authority for the far-reaching proposition the DA makes that the court should intervene in all circumstances, or at least the circumstances of the present case, and that DeLange justifies its standing for the type of intervention it seeks. Justice Van der Westhuizen never made a finding in that regard. Ms. Hassim has dealt with paragraphs 83 and 84 of the judgment. We ask the court to consider paragraph 85 of the judgment, where the learned judge made it quite clear that that issue of whether the court should intervene in private law relationship, it's a vexed question. And he was not prepared to make definitive findings in that regard. He left the issue to be decided through the private law arbitration the parties had agreed to. And so we would submit that the judgment does not assist the DA at all. It is not an authority of the kind the DA suggests. We would have been surprised if Justice Van der Vesthuizen's remarks were an authority the DA relies on, because there were earlier judgments of the Constitutional Court, one of which is Glenister 1, and I'd like to refer to it again because it is quite important in support of the proposition made earlier by my learned friend Mr. Salukazan yesterday relating to paragraph 53 of the judgment. I'd like to start off though with paragraph 47 of the judgment. My apologies. I wanted to refer the court to a paragraph, I think it's paragraph 17, where the court records the number of parties before it. And it is important because one of the parties before the court in Glenister 1 was the DA. But Glenister 1, it's important beyond the participation of the DA because it makes it quite clear in paragraph 48, 54 and 53 that a political party is entitled to advance its policies in formulating legislation. And it is only the legislation once made which would give rise to constitutional concerns if ever they are alleged against that legislation. And the Constitutional Court made that finding in paragraph 53 because of the multi-party democracy of the kind the Constitution envisioned. Parties compete with each other based on their political policies. And the court concluded that there is nothing wrong in a party taking into account its political policies in formulating legislation. The second judgment, which Mr. Salugazana referred to, relating to the right of political parties, is the judgment of the Constitutional Court in the last of the public protector legal battles with the President, the 2021 judgment. We would respectfully ask the court to consider the full bench judgment, which ultimately was considered by the Constitutional Court. That judgment has now been reported, and it is reported in under the name President of the Republic of South Africa and another versus Public Protector and others. 2020, Volume 2, All South African Law Reports, page 865, and it's a full judgment of this court. the relevant paragraphs which deals with the remit of the court to intervene in regards to private matters relating to constitutional matters generally are paragraphs 104 to 106. And the Constitutional Court found that the public protector unlawfully arrogated to herself the power of investigation relating to private party political matters relating to the so-called CR17 donations. But all of these judgments are important for one thing, because they go back to the central concern relating to the court. Why should the court intervene? Our learned friend pointed to section 1721A of the Constitution, which says that this court must grant a declaration of invalidity relating to law or conduct inconsistent with the Constitution, but not in general terms, to the extent of the inconsistency. That part of the powers of the court, we would ask the court to consider it in the light of the supremacy provision of the Constitution in section 2, because the section itself repeats the phrase law and conduct. All law and conduct inconsistent with the Constitution is invalid to the extent of the Constitution. The DA does not suggest at all that the deployment policy of the ANC is law. It can hardly ever be. So that the only issue which arises is whether the policy is conduct. We have looked at the heads of the DA. They suggest in different parts of the heads that the policy is conduct. We don't know why the DA suggests that the policy is conduct. In the light of the very extract of Justice Zondo that we have referenced, where the learned judge says that you look at the exercise of public power in order to assess whether it is unlawful. It is the exercise of public power. The DA does not suggest at all that the mere existence of the policy constitutes the exercise of public power. It cannot do so in the light of the useful judgments of the Supreme Court of Appeal in the Grey Marines case. There is nothing in the existence of the policy itself which constitutes the exercise of public power. It may be the taking into account of the policy by the relevant executive authority which may give rise to the exercise of public power. And therefore, we would submit that the DA is mistaken when it suggests on its own that the policy by its mere existence is the exercise of public power. It is not hard to understand why that proposition by the DA would be far-reaching, because it would mean that every policy of the kind which an opposing political party raises issue about will be the exercise of public power. One merely has to state that proposition, simply to reject it because of its absurdity. The next point that I'd like to deal with quite quickly is the question of remedies. And I do so by asking the court to look at the version of the DA relating to Mr. Moyani. My learned friend Ms. Hassim has dealt with it, but I'd like to give the court references which is readily available. On case line is 002-38, paragraph 88, And it continues to page 002-40, paragraph 93. From paragraph 88 to paragraph 91, the DA deals with the evidence which was presented before the State Capture Commission around Mr. Moyane. What the DA does not do is to give the court a useful analysis of where Mr. Moyane's appointment falls within the dichotomy of the public administration and the public service specifically. I'd like to take the court to the provisions of the Constitution, which I believe have now been uploaded on Caseline. And it is specifically section 1954. As Mr. Salugazana located, may I read it to the court in the interest of time? What 1954 says, the appointment in public administration of a number of persons on policy considerations is not precluded, but national legislation must regulate these appointments in the public service, so that there is not a general prohibition against appointment of persons having regard to policy considerations. The debate we may have with the DA is this: whether national policy whether the type of policy referred to in section 195 subsection 4 is the type of policy referred to in section 85 formulated by the executive authority, or whether it is a type of policy of the ruling party considered by Justice Zondo and contemplated by the Constitutional Court in the Janista judgment. We submit that that debate is unnecessary for the present purposes, because the court need not reach that question. The only observation we made is that the mere existence of the policy itself is not precluded in the appointment of persons. The next provision I'd like to deal with, and I'll skip section 196, I'll come back to it, is section 197. Okay. It's at case line 007-8. Section 1971 says the following: within public administration, there is a public service for the Republic, which must function and be structured in terms of national legislation, and which must loyally execute lawful policies of the government of the day. So that section 197 does two things, repeating in some parts what section 1954 has said. The first thing it does is to make a clear distinction between the public administration and the public service. The second point it makes is that the public service is entitled to execute lawful policies of the government of the day. And then in subsection 2, it says the terms and conditions of employment in the public service must be regulated by national legislation. Employees are entitled to fair pension as regulated by national legislation. We assume that we would have no debate with the DA when we say that the Public Service Act is the legislation referred to in section 197 subsection 2. Bearing that distinction in mind, I ask the court to go back to section 196. And remember, this is a section which we have contended had been certified by the Constitutional Court in the second certification judgment as being consistent with the constitutional principles in 29 and 30. May I give the court the reference to the second certification judgment? It is reported under the title, Certification of the Amended Text of the Republic of Constitution of the Constitution of the Republic of South Africa, reported in 1997, Volume 2, South African Law Reports, page 97, the judgment of the Constitutional Court, and the relevant passages that dealt with the certification of section 196 are at paragraphs 131 to 144. Bearing in mind that distinction between public administration and public service, section 196 does the following. And Justice Lidwabe goes to the questions you raised with our learned friends about effective remedies. In subsection 1, it establishes the Public Service Commission. In subsection 2, it tells us that the commission must be independent and impartial and must exercise its powers and perform functions without fear, favor, or prejudice. And in subsection 4, it tells us what are the powers of the commissioners. And I'd like to reflect on some of the powers identified in subparagraph 4. The first is paragraph B, to investigate, monitor, and evaluate the organization and administration and personnel practices of the public service. C, to propose measures to ensure effective and efficient performance within the public service. D, to give directions aimed at ensuring that personnel procedures relating to recruitment, transfers, promotion, dismissal comply with the values and principles set out in section 195. Now skip E, I go to F, and that is critical to your question, Justice Lidwabe. Either of its own accord or on receipt of any complaint, Roman 1, to investigate and evaluate application for personnel and public administration practices, and to report to the relevant executive authority and legislator. Roman 3, to monitor and investigate adherence to applicable procedures in the public service. We now know that under this section, the Public Service Commission can investigate the type of complaints the DA raises within the public service. And then there is a provision in the Public Service Act, and I believe that the Public Service Act is also uploaded in case line. Section 5. It's section 5, subsection 8, 007-16. And they're crucial because subparagraph A of subsection 8 says, the Commission may investigate compliance with this Act and may issue directions contemplated in section 196, subsection 4D of the Constitution, in order to ensure compliance with this Act and in order to provide advice to promote sound public administration. B, if the Commission issues a direction contemplated in paragraph A, the relevant executive authority or head of the department, as the case may be, shall implement that direction as soon as possible. We will submit that therein lies effective remedies in case the DA claims that there is or there might in the future be appointments that are not consistent with the provisions of the Public Service Act. The remedy is available to the DA. It is inexpensive. It is effective because a direction issued by the Commission is one that carries with it powers of compulsion against any executive authority, which has appointed a person inconsistent with the Act. Then I go to that familiar complaint of Mr. Moyane. I have indicated to the court where the DA makes its case relating to the evidence before the Commission. And I asked the court to go back to the founding affidavit of the DA at 002-39, paragraph 92, because the Commission there makes findings around the appointment of Mr. Moyane as the Commissioner. I'd like to make 2 points, insofar as the DA may suggest that that's a type of evidence showing a link between deployment and the invalidity of the Public Service Act. My learned friend, Ms. Hassim, has indicated to the court why the version put up by the DA relating to Mr. Moyane does not suggest that the deployment policy was engaged in that regard, because the DA has not put up evidence to show that Mr. Moyane was appointed as a result of the recommendation of the deployment committee. I'm not going to repeat what she has said in that regard. I really wish to make the point that the DA's case fails as a matter of law. The first point we would like to make is that, bearing in mind the distinction between public administration and public service, there is a law called the South African Revenue Service Act, number 34 of 1997. That law specifically establishes SARS as an organ of state, and it provides for the appointment of a commissioner such as Mr. Moyane in section 6 of it. But for the present purposes, I'd like to refer the court to section 2 of the SARS Act. It says the South African Revenue Service is hereby established as an organ of state within the public administration, but as an institution outside the public service. So that this section 2 of the SARS Act repeats and rely on the dichotomy or the distinction section 197 makes, that there may be aspects of the public administration which fall outside the public service. And one example of it is SARS. Mr. Moyane was not appointed in terms of section 11 and section 10 of the Public Service Act. He was appointed by the Minister of Finance as provided for in section 6. So that if there were questions around deployment, unlawful deployment of Mr. Moyane, those would have been dealt with under the SARS Act, and they would have related to the Minister of Finance, not the Minister of Public Service Administration or anyone who has the power to appoint in terms of that section. What that shows is that one must be careful when you make general claims relating to deployment in the public service, because there's no evidence whatsoever the DA has presented relating to unlawful constitutional concerns in the deployment in the public service. Mr. Moyane's evidence, or the DA's evidence relating to Mr. Moyane, does not deal with deployment in the public service. The DA's reference to the evidence of the President, Minister Mantashe, and Minister Hogan don't deal with appointment in the Public Service Act. You would recall that Minister Hogan raised concerns around Mr. Maseko as against another candidate. Those were appointments not in the public service, but in public entities. So we would submit that it is the failure by the DA to understand the distinction which has led to all of these difficulties. May we then make some concluding remarks in the light of the submissions that we have made on this issue. The first is that there is no evidence whatsoever presented by the DA to show that there is law or conduct at issue which would justify intervention by the court at this stage of the proceedings in the general context of an existing policy without any indication of the application of that policy in the present or in the past relating to the public service. Secondly, we would ask the court to conclude that the type of a declaration the DA seeks will give rise to unacceptable and intractable consequences because it will give rise to potential litigation going backwards and going forward relating to the validity of appointments in the past and relating to how appointments in the future ought to be taken. And those potential consequences going forward will be based on the assumption that relevant executive authorities would exercise their powers unlawfully. And that is an assumption which we have said a court is not entitled to make. Thirdly, there is no concrete case whatsoever that would require the court to deal with a declaration of the kind the DA seeks. Fourthly, we would submit that case law makes it clear that it is always when there are decisions that have been taken which would become a subject matter of constitutional scrutiny by this court. And that is what Justice Zondo has said in the extract of the report the DA relies on. It is only in those rare exceptional cases that the court will be entitled to intervene relating to constitutional complaint before concrete decisions are taken. Genesta 1 has indicated that a person who seeks intervention by the court in those rare cases must show irreversible harm as a matter of exceptional circumstances. The DA has not made a case of exceptional circumstances manifested by irreversible harm. The best it can make about its case is that there is a policy, but the policy on its own does not present irreversible harm, because any harm which may happen as a result of the implementation of the policy, it can be reversed by this court in subsequent litigation or through the channels of investigation by the Public Service Commission.
I recall the submission was made that one of the exceptional circumstances is in cases where the procedure taken to make the police
Yes.
somewhat that the court can intervene.
Yes, so that at that level, and that makes our point, it is only when the procedure is applied, when the policy is applied in a manner which is unlawful, or in a manner that gives rise to undue influence. So there has to be something more than the mere existence of the policy, which would invite the court to intervene. And that's why, in this case, you as a learned friend, time and again, are you saying the mere existence of the policy is a problem, or is it the implementation of the policy itself which would give rise to a problem? We have made our submissions to show that what Justice Zondo had in mind was the implementation of the policy, taking that policy into account going forward in making the appointments. I don't understand why the DA would say that the mere existence of the policy itself would be unlawful or unconstitutional, especially in the light of paragraph 53 of the Janista 1 judgment we have referred to, especially in the light of the conclusion by the full bench of this court in paragraphs 104 to 106 in the full bench judgment of the last of the sagas between the President and the Public Protector. Because those paragraphs acknowledge as a matter of constitutional soundness that a ruling party may be entitled to take into account its policies in a multi-party democracy in implementing law or whatever decision. It is only once the law or decisions concerned have been taken that there would become questions of interference by the court. And so we would submit that the mere existence of the policy is not good enough. There has to be something more to it, as Justice Zondo has indicated.
Cases or to a specific case where a decision has been taken based on the policy.
The best it has made, a decision taken based on a policy, is that Mlokoti judgment. But recall that what was challenged in that case was the unlawful appointment and not the invalidity of the policy. And that's where the distinction lies, that you look at, and the reason is quite clear, we would submit, because it is the exercise of public power by a public functionary which would give rise to public concerns. It is not the exercise of a private party political policy outside the remit of public power which would give rise to political concerns. Justice Lidwaba, I was at the concluding part of our submission, and we would conclude then by submitting that the minister is entitled to be before this court. We would ask the court to take into account the submissions we made on behalf of the minister. As I said, I'm not going to make any issue around the question of cost. I'll leave it to the court to decide that question. And unless the court has further submissions, those would be our submissions. But let me confer with my learned junior to make sure that I do not shortchange him.
I accept, but I do not take issue with your submission on the findings of the commission.
Yes.
But you may want to relook at paragraph 84 of the case.
Paragraph 34 of my head.
84.
84. And let me confess that these are the heads which have been dutifully and diligently prepared by my learned junior. Let me disown a poison pass in advance. Help me? Yeah. Again, it's that exuberance of my junior. I would respectfully submit that it does not reflect what Justice Zondo did. And I'm not going to suggest that the court should take into account that submission. It's clearly wrong based on the text of what Justice Zondo said. Thank you, Justice Lidwaba.
Justice Ledwaba, I've been asked by counsel for the amicus whether we have any objection to him asking the court to make a 2-minute submission. And we have no objection to that, but we'd prefer his request and any submissions he wishes to make to be made before I commence with my reply. I think it's to do with the costs that the ANC asks against the amicus, but I would like to go last. So if he is going to make a request, I prefer him to make the request now.
Can you give me the request so we can exactly what was
May it please the court, Lord. The ANC in their heads of argument do not seek costs against the amicus. For the first time they asked for costs after the amicus spoke. And it strikes me that it would be just in the circumstances for the amicus to give them an opportunity to address that question.
So when you say the ANC, you're referring to the fully respondents?
Yes.
How long are you going to take you to submission? I think you will take more than 2 minutes.
It won't be more than a few minutes.
Okay, continue. That's on the issue.
My Lord, as I mentioned, Mr. Morrison sought costs against the amicus. First of all, the general rule is that amici are not entitled to receive costs, and that it's very rare for costs to be awarded against them. There are a number of cases which deal with the question around costs. The case of Hoffman versus South African Airways points out that the amici is in a unique situation in the sense that it's a friend of the court, and that its role is to provide information to the court. I would submit that. Beg your pardon, my Lord?
When each case you provide information to the court, or when the information that is provided is not of any assistance to the court, can the court consider the question of cost?
Well, my Lord, in the matter of Lakota versus the National Speaker, it was argued that the amicus didn't fulfill that requirement in providing useful information, and costs were sought against the amicus there, and the court declined to provide costs.
That is the case?
Yes. It is the case of Lakota and another versus Speaker of the National Assembly and another. Citation is 2015-4, SA 133, paragraph 53. Lord, I would submit that in this particular case, the amicus has provided unique arguments before this court. In my address, I raised the question around non-racialism being one of the foundational values, the question around unfair discrimination, how it relates to Section 9 of the Constitution, how it relates to Section 11 of the PSA, the questions around the economic damage caused by the cadre deployment policy, and the ANC's efforts to undermine press freedom. Now, those are unique submissions, and I would submit that they can be considered by this court in determining its judgment.
You also raised some powerful remarks in your opinion that power tends to corrupt, and absolute power corrupts absolutely.
Yes, my Lord. I also submit that the Biowatch principle talks not about just private parties litigating against the state, but the idea that in constitutional litigation, it must be determined whether there is a concern against awarding costs against parties when there's a constitutional issue present. And it mentions the chilling effect that would be present. If this court were to grant costs against an amicus, it would send an enormous chilling effect on civil society organizations that join in proceedings to assist the court with unique arguments, and it would chill them into silence, many of which who would have participated would no longer participate. And on that basis, I'd submit that the amicus ought not to have any costs awarded against it. and it does not seek costs against any parties. And of course, all of the parties agreed to the amicus being present in this case. They were aware of the arguments that would be raised through the application, through the heads of argument, and through the original letter, and there were no objections.
Mr. Opperman, I have a question. And the difficulty that the court finds itself in this case is that the coming in of the amici was not via a decision made by the court. It was by agreement by the parties. Now, if you look at the outer case and it's the MSc of Education, the toilet case where the child dropped into a long drop and died. The role of the amici is adequately set out here. So what I would need you to explain to the court is, given the submissions of the amici that appear to make a common cause with the applicant, given the role and the use that the amici made to the court, should the court not deviate from the principle of not in case a cost against the amici?
But not. In Hoffman, the court states the following. An amicus chooses the side it wishes to join unless requested by the court to urge a particular position. An amicus, regardless of the side it joins, is neither a winner nor a loser and is generally not entitled to be awarded costs. So there's no prohibition on supporting one of the parties. In other words, it's very commonplace for an amicus to say the relief sought by the respondent is good relief, the relief sought by the applicant is good relief. So to say that you've made common cause and you ought to be treated like an applicant just appears to be out of kilter with the way the case law works on amici. I would submit that it's perfectly acceptable and generally found that an amicus will say this relief is good for these reasons and we support it for these other reasons which are different from the applicants, and that's what's happened in this matter. In other words, AfriForum does not appear here as an applicant, it appears as an amicus. It has provided unique reasons for why the relief sought by the DA ought to be granted, and on that basis ought not to be mocked in costs.
You accept the comments of the former DCJ in the outer case that an amici cannot adopt a partisan stance. Do you accept that?
Well, the language in Hoffman implies that there's a joining of a side, which in other words means ultimately the amicus is a friend of the court, and its obligation is to provide the court with good arguments in favour of position. But it would be strange to say nothing about the relief that was sought by the applicant. In other words, the reasons provided by the amicus are good, substantive, independent reasons for granting the relief sought by the applicant. It's not a matter of partisanship, it's a matter of providing argument before this court on the question before the court.
Thank you. It was important to get those answers.
Yes.
I think maybe for completeness sake, Mr. Morrison. You raised this point. You wish to make a comment before answer the plan?
If I may, thank you. The first point we'd like to make is that costs are discretionary in the hands of the court of first instance. The second is that Firewatch will obviously be taken into account. Firewatch confined cases where there was a genuine constitutional point. The issue here is whether there is a genuine constitutional point raised by the amicus in a manner that was within the confines of what an amicus can do. Firewatch is not designed to protect parties or amici from abuses. Where the process is abused, costs are appropriate in our submission. In our submission, the amicus abused the privilege of being allowed in as a friend of the court. They used the opportunity to make a partisan contribution in conflict with the authority in outer, and they used the publicity available in the case and the media presence to make a political statement which went beyond the scope of the papers that they had filed with reference to inter alia, their state of the power supply in the Johannesburg High Court, the number of days of load shedding that we had last year, and the composition of the African National Congress leadership. Those 3 points were not raised on their papers, they were raised in the course of the argument, and they were made with a particular objective of advancing a partisan interest. Under those circumstances, we would submit that the request for costs is appropriate, that BioWatch does not protect the abuse of an amicus's office under the circumstances, and that in fact an attorney-client costs order is being risked by the conduct of the amicus here. There is no chilling effect created by ordering costs against the amicus under these circumstances, because all that it does is that it says to amici who try to use important matters of law to advance political agendas that you can't do. You can't abuse your privilege as an amicus to advance a political and partisan agenda. You can't go outside the papers, you can't go outside the role of an amicus as recognized in the many decisions, one of which has been referred to by the learned Justice Bank, as the court pleases. And if I can, with the assistance of my learned friend, refer the court to a particular case in relation to the granting of costs against amici, Lawyers for Human Rights versus Minister in the Presidency and others, 2017 1 SA 645 CC, 2017 1 SA 645 CC. As the court pleases.
I saw you
Thank you, my lord. We do not seek course. I merely wanted to make the same reference to the case, Lawyers for Human Rights, that Mr. Morrison just did for the purpose of assisting the court. And the point is merely that the case says that the BioWatch principle does not endorse risk-free constitutional litigation.
Thank you, Justice Ndwaba and the other two justices.
you wish to tell me that you are going to reply?
I wish to reply. Yes.
Okay. Then let's adjourn and we'll start.
What? I've forgotten what time you had indicated that. How much time I'd have, and I just forgot.
Unless if you're going to take 5 minutes, I can allow you.
So 5 minutes. I'm happy with no time. I'm happy to start. I'm also happy to take as much time as you. Well, obviously, I'm in the hands of the court.
I think it would be appropriate to let's adjourn and then we can reflect on all the submissions made and then we'll resume
At 2. Well, I'm just wondering. I hope I've got. And what time are we finishing? So I can plan my argument between now and 2. I thought.
Initially, we said that I should not be more than an hour.
And I've got till 3:30. That's more than enough time. If we start at 2,
We
yes.
started at 2, so I think you can go up to about 2 o'clock.
Then I'll tailor my argument for that hour as previously. Thank you.
You gonna any? Then I want to go out and just refresh me. They used to have a coffee shop here. Where's there? The place. Okay, I'll walk there. Yeah. We can walk there if you go in there. If not, I'll see you after.
I think let's take the laptops. Yeah, let's take the laptop. with you, and I know you can believe it. I normally direct for the SAE.
Okay.
I think I would should grow because for me it's more about learning. I mean, just you said here, I could not
Thank you, my Lord. In the reply, the DA intends to deal with two broad aspects of this case. The first aspect is how the DA on the one hand and all the respondents on the other have approached this court from different galaxies. The DA approached this court in a particular paradigm. Our learned friends, all three, the ANC, President, Government, and the Minister, all tell the court what the DA are seeking to do, and they say that which the DA seeks to do is incompetent, not appropriate, and the remedy is inappropriate. We would suggest, and I'll explain why, that the entire structure of our respondents' opposition demonstrates it in and of itself why the DA is entitled to the relief sought. And I'll turn to that. That's my first big topic. The second topic divides into various subtopics, and those subtopics deal with high watermarks of our learned friends' responses, such as our learned friends for the ANC started with, freedom of expression, justiciability, and I'll take 5 topics and explain why each of them redound against the respondents as a whole. My first topic is what the case is about and why, from the DA's perspective, and why our respondents have misunderstood that, mischaracterized it, and have not dealt with the DA's case in any shape or form known to litigation. In presaging that, let me start off by saying we stand by our submission that the DA is entitled to Pres 1, 2, and 3 of the Notice of Motion, together with costs, including costs of 2 counsel, such costs against the 3 opposing sets of respondents, just jointly and severally, and were the case not to be successful, then, as our learned friend for the ANC suggests, this is a serious constitutional matter. Clearly the DA be protected by Biowatch. So let me turn to the first big topic of what this case is actually about. And here I have to apologize well, not apologize, but just clarify 2 answers that I gave yesterday in respect of questions by, respectively, Justice Mojapelo and Justice Bum. And the question related to what is the case about when we challenge the policy? Is it the words of the policy? Is it the conduct? Is it the minutes of the deployment? What is it? And I gave an answer which I stand by. And our learned friends have ignored that answer entirely. And I heard 2 hours of argument from the ANC yesterday, 3 hours this morning, and you did not hear one word, Justice Mojapelo, not one word, Justice Bam, as to the content of the policy. There was one reference to the content of the policy by our learned friend for the President and the Government, and she made a very interesting, and we would submit, telling submission. She said, and I paraphrase, the DA can't quibble with some parts of the policy because they advance transformation, gender-wise, etc. What is the implication of a submission like that? That the DA can legitimately complain about other parts of the policy. So she says some parts are not offensive, some. But she never says, and none of them say, the policy itself is defendable. All of their defenses are why the court can't go into the policy. And I wish to take the court into the policy to explain what the DA's case is about. So all this question of alternative remedy, declare, it doesn't go to the heart of the DA's case, because that's not the DA's case. The DA comes to court to say one thing and one thing only. This policy, which I'm going to take the court to in detail, is unconstitutional. So you have a constitution, and you've got to measure this policy against the constitution. And our primary submission yesterday was that it's the policy, not how it's implemented, that is at stake. And there are cases where they say that where you have a challenge to a law or a directive or some document, and the argument could be, well, you shouldn't challenge the law or the document, you should challenge the decision under it. There are some occasions where those two things are so interlinked, it's appropriate to challenge the document itself. It's a case called Ahmed, paragraph 43, and my learned friend will email the judgment of the Constitutional Court. But let me start off with what is the Constitution about? In South Africa, we have a constitutional democracy. Our learned friend for the minister this morning mentioned at the end of his address, this is a multi-party democracy. It's not. It's a constitutional democracy with certain values. The first value is the supremacy of the Constitution and the rule of law. That's section 2. C. D says there's various aspects to that value, and the sovereign democratic state founded on the value of universal adult suffrage, a national common voters' roll, regular elections, and a multi-party system of democratic government. And we will submit, and we submit firmly, that this policy undermines the notion of a multi-party system of democratic government. That's our submission, and we stand by the submission. And your Lordship has not heard a word about the policy. May I take the court to the policy, FA2, on page 118. And we stand by the questions of 195, 197, as we've articulated in the pleadings, in our heads of argument, etc. But I need to take the court to the policy itself, because when one goes to the policy, as Justice Mojapela put to me yesterday, is there a word in the policy that talks about dictation? And I'll come to it. And I answered, one looks at it in through a particular lens. And the lens is this: the words, the text, the purpose, and the context. That's what Undameni says. That's how this court will look at this policy. And we start with the policy on page 11. The case line's reference is 002, page 60. And it starts off with the genesis of the policy, and it turns on to the next page, which is 61, and in paragraph 6, I would like to read, and I'd like to take this in detail, because as I develop the content of the policy, one sees the words, you don't even have to go to context or purpose, undermine the rule of law and the notion of a constitutional democracy based on multi-party system of government. And if you come to the conclusion that we are right on that, all of these other debates, fascinating, but irrelevant for the purpose of the DA's case. So what is said in paragraph 6 of the policy is the National Conference recognized that a cadre policy can only flourish within the context of a mobilized, strong, and active organization. And then we read what has to be done. So they resolved to put in place a deployment strategy which focuses on the short, medium, and long-term challenges, identifying the key centers of power, our strategy to transform these centers of power, and the attributes of skills we require from our cadres to do so effectively. Then it goes on to 6.2.1 to do various things, discuss the deployment of cadres to areas of work on behalf of the movement, including public service, parastatals, structures of the movement, and the private sector. And we turn over, importantly, Justice Mojapela's point, 6.2.5. Decisions of the organization after appropriate consultation with individual cadres are final, and a breach of this policy shall constitute a serious offense to be considered by the appropriate structure. So when there's a cadre who's deployed, he's the minister, and he breaches a recommendation, he is therefore subject to this policy, which is a breach of this policy shall constitute a serious offense to be considered by the appropriate structure. And then the framework is set out in 8 to 11. And the framework of the policy tells the court that this is a document which undermines the Constitution and multi-party democratic system of government. One just has to read it to see that. The words itself. Let me start by the key centers of authority and responsibility of power diffused throughout society and located both within and out the state. Our approach, the ANC's approach to deployment, must therefore be sensitive to that reality. Our immediate goal, this is the goal, the purpose, as set out in the strategy and tactic, is to deepen the hold, and I want to emphasize, the hold of the liberation movement, one presumes that's the ANC, over the levers of the state. So they're holding the levers of the state and begin to impact positively on other centres, that's not the state, of authority and responsibility outside the immediate realm of the state institutions. And then 10 is divided in, so 10 and 11 are the various centres of power that are identified for the liberation movement to take hold of and across. 10 talks of the cabinet. We have no difficulty with that as a matter of principle, subject to saying that the president is the person who is the head of state, head of the national executive, and to whom the cabinet responds, not the ANC. So they want to take hold of that lever of authority. The entire civil service. We emphasize they want to take hold of the entire civil service. That's the goal. And they tell the court that's the goal. But most importantly, from director level upwards, so from director upwards, premiers and provincial administrations, legislatures, local government, parastatals, and I'll pause at 10.7, education institutions, universities, schools, principals, teachers. These are all levers of power that the ANC say they want to control. Then we go to the next one, 10.8, which we submit should be alarming to this court. And we emphasize the words independent, statutory commissions. One thinks of the Competition Commission. There are a host of independent statutory commissions which now the ANC want to control or hold lever over. Agencies. I'm not sure that the statutory commission includes the IEC, the body tasked with elections in this country. We're talking about a multi-party democracy. I said agencies, boards, and institutes. One wonders the court should think, does this include the public protector? 10.9, ambassadorial appointments. 10.10, international organizations and institutions. 11. And here is something that the court will reflect on. 11.1. The ANC want to hold levers of power over whom? The media. It's rich for the ANC to defend this policy by saying it's our freedom of expression when has regard to the ANC and everybody else's right to freedom of expression. In 16 of the Constitution, section 16, it includes A, freedom of the press and other media. So the Constitution gives us all a right to freedom of the media, yet in the ANC's approach, they would hold the levers of power over the media. And we,
Just to be sure that I follow your argument, if the ANC was a minority party, the case would pursue this application.
absolutely.
So, in essence, you are saying that if there's any other political party which has got this process, the DA is going to bring an application that those policies be satisfied.
No, look, Justice Ledwaba, the answer is this. And I was trying to think of examples. And one of the court staff yesterday spoke to me about, for example, a trial that took place in the court upstairs for a couple of years, the Boerenweg trial. And if there is an organization, a political party, an NGO, or a paramilitary organization which has as its policy to undermine the role of the state, whatever that might mean, treasonous or otherwise, they can be charged criminally. But any other party with standing, which would be anybody, generous standing, giant concerts, would have standing to challenge any organization, any political party's policy which is there to undermine the state. And if the ANC or any other party was in the minority, and I worry about minorities because one knows with the way the future of South Africa, we're going to coalition politics. So the questions of majority or minority may not be as important as they are now because we've lived for 30 years with a majority party. But it becomes irrelevant when we live in, for example, we know that on Friday there will be a motion no conference in the Johannesburg City Council in respect of a DA, I think it's a DA mayor. The issue is irrelevant. There is a body called the ANC which has as its policy to undermine the constitutional scheme that the Constitution has adopted, which is a multi-party system of democratic government. They aim to take over all of these, have a hold on the IEC, Public Protector, universities, Transnet, ESCOM, Trade and Tariffs Commission, the media. That's their stated policy. Those are the words. And if that deployee violates the deployment aspect, the deployment policy says that's a serious breach subject to sanction by the appropriate structure. And I turn to, for example, and let me just say, I'll come back to it. As I read through that, the entire policy is infused with the notion of moving towards this notion of a one-party state. And they're not bits and pieces that one can say. And there's been a big complaint, what's vague? We haven't challenged a specific part of the policy. How does one challenge a policy like this? Oh, do we cut out the media? Do we cut out independent institutions? Do we cut out, or does the court cut out where it says, in paragraph 47, deployment within, for example, the judiciary? Cut it out, because we know that's ridiculous from a constitutional perspective. This entire policy undermines what we are here about today, the Constitution.
What I wanted to understand from you is that the prayer sought by the DA, is it only in respect of the ANC as a political party, or is a prayer saying any political party in terms of this process, those processes?
Well, the prayer, there's been a lot of suggestion about the prayer is abstract and it's vague and it's general. This prayer is far from abstract. It's about one particular policy. And this prayer that we seek, prayer 1, prayer 2, and prayer 3, go to that one concrete example of this particular policy. If there is party B, which comes along with the same policy, word for word, the DA will challenge that policy. If the DA develops this policy itself, the DA would expect and would be hard-pressed to defend the policy when it itself says this type of policy is unconstitutional, is unacceptable from a constitutional perspective. You understand? As a piece of the court. And we move on to paragraph 13 of the policy. Whilst the ANC structures should be responsible for final decisions with requested deployment, a dynamic and continuous interaction must be maintained between the deployment committee and the alliance secretariat, etc. And I asked that the court go through the entire policy and considers, for example, paragraph 41 on case line 00269, where these are examples to show why the policy drips with unconstitutionality. Every pore of this policy is problematic from that perspective. It says the president, the premier, members of the executive must provide regular reports to the political structures and explain how the policies are being implemented, monitored, and evaluated by government. Now, what we would submit is the appropriate accountability mechanism for the president would be in the National Assembly. For the premier, it would be the provincial legislature. And for members of the executive, it would clearly be both to the president, who's head, and to the National Assembly, but not to a political party. And this relates not just to, for example, those members who are members of the ANC, because it talks about all. So, for example, strictly speaking on the wording of it, all premiers, including the Premier of the Western Cape, who's not a member of the ANC, a member of the DA, would have to report. And if he didn't report, well, the consequences are what they are. And I do emphasize, and I do want to emphasize, that paragraph 46, 47, which I spoke to yesterday. And your lordships and your ladyship didn't hear one word, not a word, defending it or distinguishing it, saying why it's not unconstitutional, nothing. And I repeat, and it should sign not amber lights, red lights when I read what I read to you yesterday. And it wasn't a word. 5 hours I listened, and I was waiting for those words to come up. The strategy and tactics document identifies the following centers as pivotal to national democratic transformation. 46.1, the state. And then there are 4 others. 46.2, the state. 46.3, the state. 46.4, the state. 46.5, the state. 46.6, the state. 46.7, the state. 46.8, the state. 46.9, the state. 46.9, the state. 46.10, the state. 46.11, the state. 46.12, the state. 46.13, the state. 46.14, the state. 46.15, the state. 46.16, the state. 46.17, the state. 46.18, the state. 46.19, the state. 46.20, the state. 46.21, the state. 46.22, the state. 46.23, the state. 46.24, the state. 46.25, the state. 46.26, the state. 46.27, the state. 46.28, the state. 46.29, the state. 46.30, the state. 46.31, the state. 46.32, the state. 46.33, the state. 46.34, the state. 46.35, the state. 46.36, the state. 46.37, the state. 46.38, the state. 46.39, the state. 46.40, the state. 46.41, And then the economy, organizational work, etc. But the important proposition for our purposes is not a word in response. And I understand why. Because it's indefensible. They cannot defend this. Deployment within each of the 5 pillars requires its own set of strategic discussions. For example, within the state sector, what principles should inform the deployment of cadres to institutions with judicial or investigative functions? There is deployment to judicial and investigative functions, and I made the point yesterday. And there is no answer to that. You haven't heard an answer. And the reason that you haven't heard an answer with respect to 5 hours of oral argument, all the written argument, because there is no answer. And I want to turn to the various aspects so what we submit is as a whole. It doesn't matter if they're good bits, bad bits. The policy as a whole, to its core, violates the notion of the rule of law. And it doesn't matter, as the minister put it this morning, there's a distinction between the public administration, the public service, or there's this, the word only appears here, or the word that appears there. This policy at its heart is, I read the media myself, and I wake up and look on my phone and I see myself quoted about cancer. So I'm going to try to avoid saying, and I was thinking of saying, that there's 6 hours of oral argument. Like the plague, our learned friends avoided the policy. And one smiles. It's not funny. It's serious. This is a serious case. And all that our learned friends did was put up blocks to say to the 3 wise judges, don't look at that policy. That's what we've heard. 6 hours. Freedom of expression. The ANC says, if we can't say, Professor Moyane, I don't know what professor, sorry, Tom Moyane, is the appropriate person for SARS, and the Minister of Finance does or doesn't, it violates their freedom of expression. Let me turn it on its head and let's see what the true submission is about freedom of expression. The ANC don't say, quite correctly, and they're correct, that if there was undue influence in an appointment, it wouldn't violate their freedom of expression. They can't say that. How could it ever be that I can violate a whole series of laws by expressing myself? And I come to the court and I say, don't worry about my violation of the laws, it's my freedom of expression. It can never be. So if they go along to the minister and they say to the minister, Minister, you appoint Mr. X or else, they won't ever suggest that that is constitutional as a part of their freedom of expression. So all they say is, well, we're allowed to whisper in the ear. We're allowed to nominate. It's not freedom of expression. Freedom of expression is something very different to what they say. And they have to accept, as they do, and we accept that they do, and I haven't got a problem with them, that it would not be a violation of freedom of expression to dictate. So they accept that they can't dictate, but they say, no, we're only recommending, therefore, it's our freedom of expression, when they know they can't use dictation to justify, or freedom of expression to justify dictation. So freedom of expression, we submit, is a red herring. I don't want to, it's unnecessary, given the heart of our case, to go into the technical difficulties that our learned friend raised with the question of the distinction between 16.1 speech and 16.2 speech. I don't know if your Lordship heard, and there was a question of American First Amendment ideals or whatever it was, and there was this question of the difference between 16.1. Islamic Unity Convention, Justice Lange then structured and explained how the interplay between 16.1 and 16.2 speech occurs. And if I understood the ANC correctly, there was a submission, and if I'm wrong, I apologize, that 16.2 speech is somehow prohibited, but that's not the case. No speech is prohibited other than by some law. And what's the law in this case? The rule of law, 195, 197. And 16.2 only means that if there is a law then it doesn't have to be a prohibiting speech of some kind, and it's hate speech or advocacy of hatred, war, etc. That speech, the 16.2 speech, is not protected in the sense that one can't go to court and complain about the law of general application under Section 36 because it's not 16.1 speech. But I don't need to go there. I've explained to this court how this policy drips with an affront to the rule of law. The next aspect I deal with is this question of the public-private debate and the question of justiciability, and it all links to the same proposition. Ultimately, the Constitutional Assembly chose a model of constitutionalism which said that it's not only government which is subject to the Constitution, but it's us, those not in government. The guest house owner, who may not discriminate in his policy against particular race groups or particular gender-oriented people, all of us, private and public. And the ANC is saying, well, they're just a private body, they can do what they want effectively. Gets us and gets the court nowhere. They are subject to the Constitution. They are subject to this question of respecting the rule of law, respecting multi-party democracy, just like every other person and organization in society. So we would submit that the justiciability argument in the private-public debate is not one that should detain this court for any length of time at all. The next debate that I wish to touch upon that they raised was, and this is an important proposition, the appropriateness of the declaratory orders. Now, there was talk, and I go on a very high level because it's all fascinating, but irrelevant to the DA's case, and that's what I said at the start. There's NAPTOSA, there's this question of, as I recall, provision dealing with declaratory orders under the Supreme Court Act, now the Superior Courts Act, and the court has a discretion. Your lordships and your ladyship heard the debate. Irrelevant. That's not what this case is about. This case is about a pleaded constitutional declarator. If one looks at paragraph 1, it says the policy is inconsistent with the Constitution and invalid. That is classically no more, no less than a 172(1)A declaration. And to talk about Section 21 of the Superior Courts Act or the Supreme Court Act and discretion has no place in this constitutional case. It's just not available to any party to make that submission. And when we go to the appropriateness of the declaratory orders, I have two broad submissions. The one is, as long ago as Darwood was the first case that the Constitutional Court decided that where the court considers law or conduct, and it comes to the conclusion that this law or conduct is inconsistent with the Constitution, it has no discretion. It must declare, bearing in mind the words of 172(1)A. Must declare. And what the court always has a discretion in every single case that comes before it in a constitutional setting is to issue an order which is just and equitable under 172(1)B. So the court may, if it's so invited, make any order that's just and equitable to ameliorate the chaos that could come. And we've heard a learned friend for the ANC, a learned friend for the minister says, well, if you give this declarative, there'll be chaos. All these cases will come out of the woodwork. All of these decisions will be set aside, or potentially set aside. And I invite the court, not for me to do, it was for them to do, but I invite the court to deal with that by making an order that the court finds is just and equitable to ameliorate the potential that our learned friends talk of. All these 85 cases of cadre deployment which are suddenly up for grabs. Make an order that the declaration is only prospective. The DA will be happy with that. The DA is not here to seek chaos. But every Director General that's ever been appointed deployment through a unlawful deployment policy to be set aside, or all the decisions, that we're not here. We're here to stop what's happening in the future. So that I leave to the court. Our learned colleagues, properly speaking, should have said, well, if you are minded to make this declaration, only make it prospective. Happens every single day. And I asked the question, the appropriateness of the declaratory order. They say it's in the air. It's abstract. It's got no direct impact because it's not about a particular deployment decision. The Constitutional Court has dealt with that submission and rejected it in rail commuters. In rail commuters, the Constitutional Court said in 70, I think it's 70, sorry, my Lord, I'll give the reference. It said that it was about the trains in Cape Town. I think somebody fell off, got killed. And the question is, they came to court to say that the rail commuter organisation, it's Rail Commuters versus Transnet 2006, 2 SA Law Reports, SA 359 Constitutional Court, and they explained the importance of declaratory orders in 107. A declaratory order is a flexible remedy which can assist in clarifying legal and constitutional obligations in a manner which promotes the protection and enforcement of our Constitution and its values. That's what the Constitution says. Our learned friends, for the President, the government, and the ANC, says, don't make declaratives in the air. The Constitutional Court has said, make declaratives for that purpose. And it goes on. Declaratory orders, of course, may be accompanied by other forms of relief, such as mandatory or prohibitory orders, but they may also stand on their own. It's what we ask for. It's what the Constitutional Court sanctioned in 2006. We've heard huge arguments about this, in conflict with what the Constitutional Court has said about declaratory orders. And it goes on. In considering whether it is desirable to order mandatory or prohibitory relief in addition to the declaratory, the court will consider all relevant circumstances. It should also be borne in mind that, this is 108, that declaratory relief is of a particular value in a constitutional democracy which enables courts to declare the law on the one hand, but leave to the other arms of government, the executive and the legislature, the decision how best to implement, etc. Not entirely relevant, but the principle at stake here. And let me say what's interesting. In our replying affidavit, and I'll come to the next chapter of these different headings, is pleadings. There was a complaint about Swissborough, that we haven't complied with Swissborough. I don't know if your Lordship, Ladyship remembers Swissborough. Because I remember it because I was here in 1997 arguing Swissborough in this very court. And it's a long judgment. It's about discovery. And it sets out as the leading case for many, many years since 1997 how pleadings are to be dealt with. And one of the important aspects, I'm going to make 2 points on the pleading point. One of the important aspects of Swissborough is that a party is at large to make any submissions on the law which are borne out by the pleadings. And these pleadings, the affidavits by the ANC, the affidavits by the President and the government, and the affidavit by the Minister, point in one direction, that the law demands that the orders that we seek be given, as a matter of pleading. But it goes worse than that. Because I'm going to refer to a case in a series of cases called, well, 2 cases, Pretoria Portland Cement. It's a judgment of Scuts, JA, versus Pretoria Portland Cement versus Competition Commission, where I think it's in paragraph 63. Justice Scuts makes the point that if in the replying affidavit an allegation is made, in that case the allegation was made in the replying affidavit that a person that I mentioned yesterday, Advocate Menzi Simelane, in the question of the President appointing in the NDPP. But in that case, I think he was the CEO of the Competition Commission. And the Competition Commission went and investigated the Pretoria Portland Cement, and he turned up at the place, and he called the press, and there was a complaint about this, and they said that he was lying on affidavit in the replying affidavit. So in the replying affidavit, for the first time, there was a suggestion that Mr. Simelane was lying in what he said about the visit to PPC. And what Scott's JA said was, where there is an imputation of dishonesty, even in the replying affidavit, and I'll give the reference is 2003, volume 2, SA 385, SCA, Scott's JA at 63 says, the last sentence, now it is true that Simelane had no right or duty to answer this allegation. It was an allegation of dishonesty made in reply, but I would have expected him to offer to do so if Gomesel's imputation, that's in the reply, of dishonesty were false. And we also asked that the court have reference to this proposition in Tantush, it's a judgment of this court, versus Refugee Appeal Board and others, 2008, Volume 1, SA 232 at 70, where Murphy J makes the same proposition. I think it's 70, and there's another paragraph, which I think I'm reading a paragraph here. It's not just that paragraph. There's another paragraph in Tantush. I think my junior's got the wrong paragraph. I think it might. Anyway, the proposition is this. Our learned friends for the ANC say, and I think for the president as well, no, it was just the ANC. Well, the DA's complaint against the president that he'd misled the commission was only made for the first time in reply. And the whole question of that we were invited to make a supplementary affidavit when the Zondo Commission report came out, but we chose not to, and therefore there's a pleading complaint. Firstly, the pleading complaint by the ANC is a bad one, because in the founding papers, we made the same allegation that we had made my client made in the reply. But what happens is this. In the founding affidavit, the allegation is made that President Ramaphosa had misled the commission. The president files an answer, and in our reply to the answer, we explain why even the answer that he gives as to the notion that he misled is not a true answer. It's a lie. So the argument goes in the replying affidavit. And now there's a complaint, which we find incredible, that we didn't plead our case in the founding affidavit to say that there was a lie. The lie was made out in the founding affidavit. It was expanded in the answering affidavit. And then in the reply, it was pointed out that the understanding of the president and the government as to the nature of the Zondo Commission findings wasn't correct. My Lord, may I just turn to something while I'm just at this topic? Justice Mojapela asked me yesterday about the question of I think he used the word, and I had a debate with him about the recommendation of the Zondo Commission, and I responded by saying there was a finding, and then the question of recommendation came over. I don't know if the court will recall that interchange that I had with Justice Mojapela. Now what happened, the true fact that happened in this case was that Justice Zondo made the finding that our learned friend for the minister repeated this morning and has been at the forefront of the debate, that the taking into consideration of cadre deployee recommendations was unlawful, unconstitutional. The court will recall that, but didn't make a recommendation there too. So it didn't say to the ANC or the president or the government, look, this cadre deployment besigheid is bad, now I want you to get rid of it. It didn't say anything like that. It just laid it bad and said you must develop plans to avoid this kind of difficulty. And what the president says is this, on case line 002518, and we submit it's startling that a president of a country can make this submission. He says, on oath, and he's just read certain things, and he says, it is clear from a reading of these paragraphs, this is of the Zondo Commission report, that they do not constitute recommendations from the State Capture Commission, but instead submissions made to the Commission on what should be contained in its recommendations. Ultimately, and this is the key to what the President tells this court, ultimately the State Capture Commission did not recommend that the CD, that's cadre deployment policy, be revoked, or that the nomination and selection of candidates be removed from the control of government ministers. What's the President telling the court? There's a commission established by the President, as our learned friend for the President made the point this morning, pursuant to the Public Protector's report. The commission makes a finding that cadre deployment is unlawful without a recommendation. And the President tells this court, well, not a problem, because there's no recommendation to revoke it. So we'll continue with this unlawful policy. It's effectively what the President tells the court. And the court will consider the 5 aspects that the President and the government put forward this morning, and the Minister put forward why it is that they so heavily oppose this application without any reference to the policy. Yes, they have a duty, they cite it, and yes, they have a duty to help the court. Help the court with what? How the government understands a particular party's policy, what the government says could happen, should happen, were the court to grant the relief. That started in Darwood. In Darwood, the Minister of Home Affairs opposed the application for confirmation to the Constitutional Court. About a week before the hearing, the Minister withdrew his opposition and withdrew the appeal. It was a counter-appeal. And a Reagan for the Constitutional Court criticized the government for not assisting the court in what would be just and equitable relief. And what we submit is, yes, we expect the government, we expect the Minister, we expect the President to assist the court in understanding this notion of undermining multi-party democracy. We expect them to do so, but we do not expect them to oppose, heavily oppose, in the way that they have. Take an interest in one party's policy compared to another, one political party's policy compared to another political party. And one suspects, just speculation, but if it was any other political party that's policy was being challenged, would the government of the day support the opposition? One wonders. If it was the UDM, the EFF, the ACDP, etc., any of those political parties whose policy was being challenged by another political party, by the DA or some other party, would the government of the day seriously have defended that policy? One wonders. With government money, with taxpayers' money? Defending a particular political party's policy with taxpayers' money. And that's the question that we made in our heads of argument. I made the point yesterday. And it's a question that the court will consider. My Lords, we submit that prayers 1, 2, and 3 ought fall to be granted with costs as I've submitted against the 3 separate teams opposing the relief sought. And as far as, and those all 3 prayers would fit under the remit of 172(1)(a) of the Constitution. We've heard no submissions in respect of just and equitable or possible just and equitable relief. And the only one that we can assist the court with is to say something along the lines of word up to the, if the court's minded to go in the 172(1)(b) route, which we invite the court to do, any order, is to consider whether to make that order prospective, retrospective, or comes into operation on the date of the order, or otherwise, as it pleases the court. Thank you.
On behalf of my colleagues, I'd like to thank you for the powerful committee submissions that they make. We believe that they will assist us in arriving at the proper order. We're not going to give judgment today, it's obvious, but judgment will be given at our earliest convenience. We are aware that it's an important matter, that the clarity is sought. We're going to postpone this matter and judgment is reserved. Court adjourns.
Cheers, Vincent. Bye-bye.
Yes, man.
Nice
See
to
you,
meet
man. We'll get home earlier.
you. Well, let's see.
Yeah. That's how I look at it.